Hello, I'm Michael Falk. I'm the General Counsel at WARF. WARF is the Wisconsin Alumni Research Foundation. It's the technology transfer management organization for the university. So we handle the patents that come out of the university from faculty, staff, and students. I'm here today to talk to you about intellectual property and give you a brief overview of copyright, trademark, trade secret, and patenting. Intellectual property. We're going to start with the broad concept of what intellectual property is. For purposes of this talk, intellectual property is things that you can get government enforcement for, that you can go to court and have enforced by a federal or state court and often get money for. Intellectual property is a broader concept, and when we talk about what we think about, all of those sorts of things, the music we generate is intellectual property. Some of it can be protected, some of it can't be. I'm interested today in talking to you about what can be protected and the different forms of protection you can seek. How do we protect intellectual property? As I said, there's patents, copyright, and trademark. Those are the major branches in US law for how to protect intellectual property. We also have trade secrets, and I'll talk briefly about those at the end. And they are what they sound like. They're keeping a valuable piece of information, a mailing list, etc., secret. But today we're going to focus on those things which we would file for through WARF or another technology transfer management organization, things like patents, trademarks, and copyrights. Briefly, a trade or service mark identifies and distinguishes the source of a good or service. A patent protects an invention, and a copyright protects an original idea and that expression of that idea. They often overlap, and you'll see in the diagrams I've provided sort of interlocking circles of patents, copyrights, and trademarks. There's lots of areas, for example, in software, where there's clear blending of the different kinds of protection you can get. You can protect software as a trade secret. You can protect it through copyright because it's in a written, tangible form, and you can protect it as a patent. And there's lots of areas where you'll see this intersection. For most of your needs, and certainly in a business setting, you would explore all the different ways in which you could protect an idea. You'd often have a trademark on the product, you'd have patents on the invention, and you'd copyright the service manuals and the other documentation that would go along with the invention. So let's go to the biggest area of protection we talk about at WARF, and that's patents. So patents protect new, useful, and non-obvious machines, processes, new medicines. When I use the words new, useful, and non-obvious, all of those have very particular meanings in the law, defined through the case law and in the statutes. New means that there's no other piece exactly like it, no other invention that's exactly like it. Non-obvious means that if we combine other pieces of prior art, other inventions and articles, it wouldn't be obvious for one skilled in the art at the time that invention was made to have made that invention. And useful means it has some utility. And the utility requirements are generally quite low for patents, but they still have to have some sort of real-world usefulness. Patent rights provide the right to exclude others from practicing your invention. And that's a really important distinction. Often people think when they get a patent, that's a right to do something. But really it's a right to exclude others from doing something. That's important because often the invention you will patent will require rights from other people, other prior patents that may read on to the invention you have. So you may have an improvement or some small modification or some big modification to previous work, and yet you'd still need rights to that work to practice your invention. Important to remember if you're a startup company, because just because you get a patent issued doesn't mean you have freedom to operate, the right to practice that invention. You may need to get rights from other people. And again, it's the right to exclude others. So a patent gives you the right to go to court and stop other people from using your invention or forcing them to pay you to use your invention. There's no patent police, so the federal law doesn't come in and police the world for you to see if someone's practicing your invention. It's your obligation and your right and opportunity to look for people who might be practicing your invention and then to go to court and ask for relief. The patent process. So briefly, on campus, and this would be true for you, any student, staff, or faculty on campus, if you conceive of an invention in the course of your work, usually reduce that to practice in some way. Reducing it to practice can be making the invention. Often in engineering, it will be a model or a simulated reduction to practice, and that's fine. It doesn't have to be the actual material, and often you can't do that. If you develop a computer chip that may be useful in computers, second generation, third generations computers that don't exist today, there may not be a practical way to test it, but you can test it in simulation and in modeling, and that's fine. Once you have that invention, you should call WARF, and your faculty advisor certainly probably done that, and other staff that you work with on campus, but students will often do so independently. We will take a look at the invention, and we have a process which we go through to decide whether it's worth the investment of the time and money to patent the invention, and then we manage those inventions for the university. We share part of the money that we bring back with the inventor group, 20%, and it's split up among the inventors on a patent of all the money we bring back on the invention, and the rest goes back to the university to fund further research. Patents are good for 20 years in the US, and that's from the date of filing. That harmonizes with the rest of the world, which has a system that's based on that 20-year. Sometimes in older books, you'll see 17 years from the date of issue. That's what the law used to be in the United States, but now it's 20 years from the date of filing. Important to know there's some distinctions between the US law and the law in other countries. One of the big distinctions is first to invent. In the US, the rest of the world awards a patent to the person who's the first to file, so the first person who got to the patent office. In the US, we have rights that go to the first to invent. Deciding who was the first to invent goes to this idea of conception and reduction to practice I talked about before. You have a separate session on lab notebooks, and that's one of the reasons lab notebooks are so important to keep, because you can show a record of conception and reduction to practice, so you can prove that you were the first to invent in this country, and under our laws that would give you rights to the patent. Another distinction with the rest of the world is on grace period and absolute novelty. The rest of the world generally requires that inventions be absolutely new. That means that you haven't made a public disclosure of the invention before. Under US law, we have a grace period, which is 1 year. That means if you publish an article in a journal, you have 1 year from the time you publish that article and make that public to file for your patent. In the rest of the world, there isn't that general grace period, and so you need to first file for a patent and then publish your article. We encourage you to do that under US law as well, and through WARF, to tell us first about an invention before an article goes to press, before you give a poster presentation, before you defend your dissertation in a public setting, because it's better for us, because we often will want to file things in other countries. For example, Europe, many inventions, we would see a market in Europe, Australia, China, and those countries don't have the same grace periods that we have in the US. I'm going to move now to trademarks. As I said, we're going to talk about 3 major areas: patents, trademarks, and copyrights, and we'll talk about trademarks a little more briefly. Trademarks are what you think of as elements of words, phrases, symbols. The Harley-Davidson logo or the sound of their motorcycles both can be trademarked. The look of a soap dispenser can be trademarked. All the words we think about naturally, like Coca-Cola and other brand names, are trademarks. Trademarks are designed to protect the identity of the goods, the sort of the source of the goods. And they're different from patents. Patents protect an invention. Trademarks protect the generator, the maker, the manufacturer of the goods. Trademarks are useful because it helps us in a complicated modern world distinguish the goods and the makers of those goods, the brand names that we trust and know, so that if you have a Coke in Madison, you know it'll taste very similar to the Coke you had in Shanghai the week before, because there's a company standing behind it that guarantees that. Trademark rights go to the first person to use them. There are federal registrations, and it's a very good idea if you want to have a trademark, and often you'll see this on products, you'll see the TM mark. The TM is before you have a trademark issued by the federal office that manages those. The trademark means you've either applied or you've just started in commerce and put the trademark symbol next to your name. Once you have it registered, you can put the R with the circle, and you'll see that on many products. But you'll also see the TM on products, and that means that they haven't yet been registered and gone through that application process. It's a good idea to register because you get extra rights in terms of how you can enforce them in federal court. But you get the trademark as soon as you start using the name in commerce. So if you start ice cream store and you name it Apple Ice Cream Store, that can be trademarked, and that you do have trademark rights in that store. Registering it gives you extra enforcement rights. Trademarks can be renewed every 10 years, and you can keep them forever as long as you're still using the trademark. That's another distinction from the patent law. Under patent law, you can apply for a patent, and there's no obligation that you use the invention. You still have rights to exclude others for 20 years. Under trademark law, you need to continue to use the mark and show that it's in commerce. Again, it goes to the origin of trademark. In trademark, we're trying to distinguish the source of goods. We're not trying to protect someone's invention. And so it's important that you're using that. If you're not using the trademark any longer, there's no reason to give you that protection over that name. There are various fair use, and that's a technical term, fair use, for trademarks. And that's when you want to use someone else's trademark without asking their permission. There's certain rights in comedy to use them in parody. There's certain rights if you're trying to compare your product to another company's product to use their trademark. Sometimes in advertising you'll see that. There's a lot of distinctions here, and it's a complicated area of law, especially now with digital technology, because it's so easy to use other people's material. But there are some uses which you can make of other people's trademarks that are fair. Finally, we'll talk about copyright protection. Copyright protects the expression of an idea. So this is the normal things you think of: a copyrighted song, a copyrighted book. Certainly all of your textbooks are copyrighted. And it gives the benefit to that author of the copyright to make some money on his or her expression of an idea. Now, I keep saying expression of an idea because it doesn't protect the underlying idea. It protects the expression, the words you actually use to describe that. So for example, if you write an engineering textbook and describe some particular item in physics, another person can write about the same subject matter and describe it in different words and get a copyright on that. So it doesn't protect the underlying idea, rather it protects the expression, the way you've described it. Copyright subject matter is quite broad: literary works, music, drama, web pages, also some software, and I talked about that briefly before, where you have a choice in software protection. If you want to copyright the code, you can also patent the business method underlying it. Copyright does not protect the ideas, and that's something I want to emphasize. Again, it's this particular expression of the idea. It also doesn't protect titles and short names. That goes to trademark law. So again, there's some overlap there when you have character names, but generally copyright is for longer expressions, longer works like a song. Obtaining copyright protection, like trademark, it happens automatically once you put something in tangible form. So a paper you wrote for a class is copyrighted to you. You can apply for registration, and you'd certainly want to do that if you were writing a book or an article that was going to go into publication to protect other people from copying it and using it without your permission. That registration, like with trademark, is through the Patent Office, and it's an easy and relatively inexpensive thing to get, and it gives you increased enforcement rights. But again, that's a distinction with patent law. In patent law, you have no natural rights to that invention until you file for your patent. Copyright and trademark, you're naturally given those rights once you create the name or the expression, but then you can apply for further protection through registration. Copyrights last a very long time, and that time keeps expanding. They're often called the Mickey Mouse laws because the Disney Corporation's been involved in getting those expanded because they have an interest in protecting characters like Mickey Mouse, which and the expressions of Mickey Mouse and the cartoons, which date from the 20s and would have expired under the old copyright laws. So copyright is a very long period of protection. Again, unlike patents, which only last for 20 years. Finally, I want to talk for a moment about trade secrets. Trade secrets come up less often in an academic setting because trade secrets are what they sound like, secrets. It's if you want to keep proprietary business information secret. It's difficult to do in a university setting because university is about educating and making information public. One of the goals of a university is to publish new research and let other people know about it. So trade secrets generally don't come up in a university context, but it's important to understand that that's another way to protect intellectual property. It's different and really the opposite of patenting. In patenting, you make patent, you make obvious, you share with the world the details of your invention. And in exchange for sharing those details, you get this limited monopoly to protect this invention for 20 years and exclude others from practicing it. In trade secrets, you keep the information secret, and you must keep it secret, and you must use various reasonable business ways to keep it secret. And then you can protect the information and not share it with the public. If someone else happens upon the same information, they can take it and use it, and you don't have enforcement rights. But you can stop people from stealing it. Kentucky Fried Chicken's recipe, certainly a classic example of this. More often you'll see in a business context, it might be a database of contacts or sales people you've called on. That might be something that you'd keep trade secret. Also, manufacturing methods. If you have certain tricks that you use as a company in manufacturing your goods, that would be useful for other people to know. You may want to try to keep those as a trade secret within the company because they give you a competitive advantage. But again, trade secrets are not the same as patents, copyrights, or trademarks. You don't register them with the government, and and you have to keep them secret. You can't share that information. So in a university context, you'll probably encounter those less often. If you want further information on patenting, trademarks, and copyright, a great source is the Patent Office, the U.S. Patent Office. And you can Google that. It's the PTO, United States Patent and Trademark Office. They have a lot of tutorials and can run you through a lot of basic examples of how to patent. And it's a great place to start if you want to do further research on your own on this interesting field. Thank you.